No.
Please mute yourself. All right, everyone, welcome to the 187 District Court. You are in a courtroom. Even though some of you may be Zooming from different locations, you are to behave as though you are in the courtroom. What that means is you cannot do anything on this Zoom screen that you could not do if you were in the courtroom. If you behave inappropriately on this Zoom, your Zoom privileges will be revoked and you will be required to appear in court. To all of the inmates, you're not allowed to use the chat box. If you use the chat box, you will be sent back. To everyone who's wearing a mask, make a decision. Either wear the mask or don't wear the mask. But wear it properly if you're going to wear it, because otherwise it's just a chin strap. To all of the attorneys, if you have a plea bargain agreement with the state, no matter how small your plea bargain may be, you need to put that in the chat box to the court coordinator. She is listed as Ferguson coordinator. Zoom user, you're not dressed appropriately. If you do not dress appropriately, and if you're not dressed appropriately within 5 minutes, you will be required to appear in court. I don't know what the issue is. I don't know why people think they can just roll out of bed and here I am, I'm in court. That doesn't work. So Zoom user, the guy in the t-shirt that has no sleeves, you're not dressed appropriately. If you don't get dressed appropriately within 5 minutes, you will be required to appear in the 187 District Court at 300 De La Rosa. All right, to everyone, today is Monday, but let's make it a happy Monday. I'm going to open up the breakout rooms. When I open up the breakout rooms, it will invite you to a breakout room. Do not go to a breakout room unless I specifically call your name and invite you to go to a breakout room. To all of those who are defendants or accused, you will hear your attorney's name. Your name will not be called. I repeat, your name will not be called. If you do not hear your attorney's name, it is because your attorney is Zooming in another courtroom. Trust me, you will get a chance to speak with your attorney. Your attorney will Zoom in. Attorneys, I'm going to call your name. That's the order in which you will appear. If you see you are on the list and you want to Zoom to another court, you're more than welcome to Zoom to another court. However, if you Zoom to another court and your name is called, you will be placed at the end of the list. Attorneys, as you can see, there are more defense attorneys than prosecutors. When I send you to a breakout room, please be patient. Think of the breakout room as a doctor's office. When the doctor calls you to the back, you're not really seeing the doctor. You're going to the back, they're checking your blood pressure and your weight. Prosecutors have the ability to move throughout the rooms and see if someone is in a breakout room. If you leave that breakout room, the prosecutor will see that that room is empty and they will skip over you and go to the next room. All right, we have Albert Gutierrez, Bridget Garza, John Gilmore, Eli Rico, Valerie Hudlin, David McLean, Kurt May, and Valerie. I called Valerie's name twice. Is there any attorney's name that I have not called? I see Alberto Rodriguez. Anyone else? All right, we'll start with Albert Gutierrez. If every attorney will tell me your client's name and whether or not they're criminal trial division or family violence.
Good morning, Your Honor. I'm here for Christopher Barbosa. It's a criminal trial division, just a motion to reduce bond, CTD. I can confer.
All right, I'll send you to breakout room number 2.
Thank you, Your Honor.
You're welcome. Bridget Garza.
Good morning, Judge Grace Tilton. It's criminal trial division. I'm not sure if she's present. I haven't been able to contact her. It was a recall from Friday.
Okay, I'll send you to breakout room number 3. John Gilmore.
Good morning, Your Honor. I'm present with Kurt May. Our client is Rogelio Espinosa. Believe he's on Zoom. And it's a family violence case.
I'll send you to number 3.
Thank you, Your Honor.
You're welcome. And is Kurt May going as well?
Yes, Your Honor, I'm here.
All right. Eli Rico.
Good morning, Your Honor. I have Roger Villarreal, and he's on Zoom, and it's a criminal trial division.
I'll send you to breakout room number 4.
Thank you, Your Honor.
Valerie Hudlin.
Good morning, Your Honor. My client is the one who just put on a shirt. He can't figure out how to rename himself, but that should be Kevin Jenkins, Your Honor. And I've been working with Marcus. We're here for a plea. I do not see, did you say to chat Norma? But I don't see Norma
Yes.
in the chat. So,
All right, she's in the office. She should be on shortly.
okay. So we're here for a plea, Your Honor.
All right, thank you. And she'll need your client's email address once she zooms in.
Okay, I sent it to her a week or so ago, but I'll resend it to her. Thank you.
Okay. Then I'll send you and your client to breakout room number 5. David McLean.
Good morning, Your Honor. I'm here on a PSI for Jonathan Dash this morning, Criminal Trial Division. We're ready. I think we just gotta get Mr. Dash. I don't see him this morning.
All right. Alberto Rodriguez.
Yes, Your Honor, I have a Jesse Solis family case, and he's in custody. And I would like to confer.
All right, I'll send you to breakout room number 6.
Thank you.
You're welcome.
And Judge, just for clarification on Mr. Dash, he is in custody.
Oh, okay, just give us a moment. We'll see where he is.
Sure, thanks, Judge.
Judge, can I see you in a breakout room?
Yes. I'll see you in breakout room number 1. Mr. Lidgy, you're to go to breakout room number 1.
Yes, ma'am.
All right, and Norma, could you see where Mr. Dash is, please?
Yes, ma'am. The judge, they're bringing him out at 9:30, Judge.
Okay.
Oh,
Hey, sir, I had a question. Was there a way y'all
Judge?
Yes.
Judge, I had already conferred with the state the
Mhm.
last setting. And this setting, I believe, was to check the status if the client had registered for a class. And she was supposed to appear on Friday, and I haven't had any contact with her. She lives in Arkansas, I believe. And so the
Mhm.
court recalled it for today. And I
Yes.
still haven't been able to have any contact with her.
Okay. All right. Is there a prosecutor available for me, please? David Martin? Meredith?
Judge.
All right. Thank you.
I'm not sure if she's online, Judge.
We are going to find out. No, there's no one here who is unaccounted for. All right, the court is calling 2021 CR 1952, State of Texas versus Grace Ann Tilton. Can I have parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Bridget Garza?
All right, this hearing was scheduled at 9 a.m. actually on July 20th. The defendant was a no-show, and the court recalled it for today for hoping that the defendant would either appear by Zoom or in person. The defendant, for the record, is not on the Zoom screen. Deputy Laura, Deputy Mejia, is there a Grace Ann Tilton in the courtroom?
No, Your Honor, she is not.
All right, defense, have you had any contact with your client?
Not since the last court setting, Your Honor.
All right, and do you have any objection, Ms. Garza, to this hearing taking place by video?
I do not.
Defense, any objection? I'm sorry, state, any objection?
No, Judge.
All right, state, any motions?
Yes, Judge. The state is asking that you forfeit or bond and issue a warrant.
All right, that'll be granted. I'll remand your client without bond. If you're able to get in touch with your client and she presents herself, the court will reconsider.
Okay, Your Honor. I'll
All
notify.
right. All right, thank you. If you have nothing else with us, you're excused.
Thank you.
Lorraine Efron.
Yes, Judge. Good morning.
Yes. Good morning. Who do you have?
I have Joe De La Cruz,
Is it criminal child abuse or family violence?
family.
Send you to breakout room number 7. A prosecutor will meet you there.
Okay, thank you, Judge.
You're welcome. All right, Mr. Gutierrez, Albert Gutierrez.
Yes, good morning, Your Honor.
Good morning. I have your agreement with the state on the bond. However, I don't have an order with your motion.
Oh,
So if you are able to email me an order, the agreed order, the court will sign it.
I will do that ASAP, Your Honor.
All right, I don't know why that doesn't print out anymore. For some reason, it never comes through.
I'm sorry about that, Judge.
Oh, no problem. And do you know, is there any type of GPS or anything? Who's the complainant in the case? Is there no contact with the complainant?
There is a no contact order already in place on the current bond, Your Honor. And I don't think there's not a GPS requirement. There is, of course, no possession of weapons and things like that, but there's already a no contact order.
All right, I don't know anything about the facts of the case, of course. So let me see if there should be any type of GPS. Marcus Sanders, are you there?
Yes, Judge.
All right, so on Christopher Barbosa, is the state asking for any type of GPS or no?
Judge, we were going to, defense had an objection to it. I informed him that sometimes the court will do it on its own. But we would like GPS. We just didn't have an agreement on it.
All right. Mr. Gutierrez, would you like us to have the hearing and hear arguments from both sides with regards to GPS?
No, that's all right, Judge. If you think that is prudent, I mean, we can leave that on there for the moment. I would say this, Your Honor, that he was originally charged with aggravated kidnapping and he was indicted for kidnapping. I don't know if that makes a difference with the judge.
Okay. All right, and I'll allow him to work. There's not going to be any objection to that. Is that correct?
That's correct, Judge.
And I'll ask that the fees be waived, or for him to be placed on indigent status.
Thank you, Your Honor.
All right, is there anything else with regards to Mr. Barbosa?
There is not, Your Honor. I will have that order prepared here quickly and have it sent over to you and Mr. Sanders.
All right, do you need to speak with your client?
Yes, Judge, please.
All right, and Mr. Gutierrez, I'll put my email address in the chat box to you, but please include the state in that email.
Yes, Your Honor.
And then Mr. Barbosa, if you go to breakout room number 2, your attorney will meet you there. And Mr. Gutierrez, when you finish with your client, if you could have him come back to the main room, please.
Yes, Your Honor. Thank you.
Alberto Rodriguez.
Yes, if I could speak briefly to my client, Jesse Solis, Your Honor.
All right. Mr. Solis, I'm going to send you to breakout room number 6. Your attorney will meet you there. Mr. McLean, your client, Mr. Dash, is here. Do you need to speak with him before we take up the sentencing?
I don't think so, Judge. We've had pretty good discussions here the last couple settings, so I think we're ready to go.
All right, who's the prosecutor on this?
Hunter is who I've been working with.
All right, let me see if he may be in a breakout room. Yes, he's in breakout room number 4. As soon as he comes back, then we'll proceed.
Thank you, Judge.
Your Honor, I can do it.
Okay. All right, the court is going to call 2021 CR 5546, State of Texas versus Jonathan David Dash. We're going to have parties announced for the record, please, for the state.
Sorry about that, Your Honor. Meredith McIntyre for the state.
For the defense.
David McLean for Jonathan Dash.
And are you Jonathan Dash?
Yes, Your Honor.
All right, we're proceeding by video. Any objections from the state?
No, Your Honor.
Any objections from the defense?
None, Your Honor.
Mr. Dash, do you have any objection with us proceeding by video?
No, Your Honor.
And the court will note for the record that the defendant entered his plea of no contest on June 23rd, 2021, and consented to appear by video. At that time, the court found there is sufficient evidence of guilt. Punishment was to be assessed at 3 years in the prison. There's a $1,000 fine probated. State opposed his application for deferred adjudication, but recommended community supervision. We were here last time and the court reset it to see about the felony drug court. My understanding is that the felony drug court is going to accept Mr. Dash. Did you receive that report, Mr. McLean?
I did, Your Honor. I received an email from felony drug court last week. And they said that as soon as he was placed on either deferred adjudication or regular probation by the court, that they would accept him in. And I believe he's got a reset for this week with them.
All right. And felony drug court is a good program, Mr. Dash. Not only will they help you, hopefully, with your drug problem, but also any mental health issues as well. And I think that will be the best place to protect the community. The only issue we have now is the state is opposed to your application for deferred adjudication. State, is there a reason you're opposed to his application for deferred adjudication?
Your Honor, it's real brief. We don't have much argument. We won't have any questions. It's purely based on the criminal history, which is included in the PSI. That was our reasoning. But we did feel like drug court was an appropriate venue for Mr. Dash.
And actually, Your Honor, if I may, last time we were here, I spoke with Hunter, and Hunter had changed his opposition to the deferred adjudication to actually a recommendation for deferred adjudication based on Mr. Dash going into the felony drug court or the Veterans Treatment Court.
All right. And
Hunter Morris
yes,
for the state.
Yes.
I vaguely recall this. I don't recall why it was reset.
Okay. All right. I do recall, now that you mentioned it, Mr. McLean, I do recall the state withdrawing their objection to his application for deferred adjudication. Thanks for reminding the court. Mr. Dash?
Yes, Your Honor.
You have a choice. Here's your choice. If you're placed on what's called community supervision or regular probation, if for any reason you were revoked, the most the court could sentence you to was 3 years in the prison. However, if I were to grant your application for deferred adjudication, if for any reason you were revoked, the court could sentence you up to 10 years in the prison. Do you understand?
Yes, Your Honor.
So would you like deferred adjudication or regular probation? I always go in hoping that people are going to be successful at probation, but you know yourself better than I do, better than your attorney does, or the state does, or probation for that matter. So do you want regular probation, which would limit your liability if at any time you are revoked, or do you want deferred adjudication? In which case, if you were revoked, the court could sentence you up to 10 years in prison.
I'll take deferred, Your Honor. I'm supposed to.
All right. I'll sentence you to 4 years deferred adjudication. There's a $1,000 fine that will be probated. Felony drug court. Take in consideration the following cause numbers: County Court Cause number 64975, 660505, Night Mag number 606857, no contact with Shearer, SHEARER, Hills Baptist Church, and 8511 Blanco Road. Restitution of $57 to SAPD for drug testing. defendant to remain in custody until transferred to felony drug court. Field visits, random, 3 times per month until further notice. UA hotline. Mr. Dash, are you able to work or are you on disability?
Your Honor, I know at this point in time, I do not have a job, but I will be looking for one.
All right, we're going to do proof of employment within 30 days of release. No employment as a home health care provider or any employment involving minors. And there'll be 100 hours of community service restitution. Rebecca, is there anything else he needs?
No, ma'am.
Mr. Dash, is there anything else you need from the court in order to be successful on this deferred adjudication?
I was hoping to be released today, Your Honor.
You will not be released until you are transferred to felony drug court. Your attorney is telling me that the transfer will happen this week. And as your attorney reminded me at the last hearing, we're actually ahead of schedule of when your sentencing date was. Is that correct, defense?
That's correct, Judge. The email that I received from felony drug court was for the 29th. And I guess I need to, for clarification, just figure out exactly how that transfer happens. Is there another hearing or how does this work?
Oh, no. What will end up happening is, since felony drug court has said they've already accepted him, he will be transferred out of this court to them. And if they've given you that date of the 29th, they're probably going to bring him over either on the 28th or 29th. And at that time, he will technically be in felony drug court. You will not be supervised by the 187 District Court. You will only come back to this court, Mr. Dash, if you successfully completed everything and you want me to come to your graduation, which I will happily do, or if they are saying we cannot work with you and they return you to the 187 District Court. Do you understand, Mr. Dash?
Yes, Your Honor.
I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we'll close the record. Mr. Dash, I'm going to send you to a breakout room. Probation is going to go over conditions with you. Here's the thing about felony drug court, Mr. Dash. It is an excellent program, but they can only do so much. If you don't want to help yourself, they can't help you. Do you understand?
Yes, Your Honor.
Do you remember the song called Harry Hippie? That's one of my favorite songs. Do you remember that?
Vaguely.
All right. And Harry Hippie, some of the lyrics are, I can't help a man if he want to live on the ground, So you're going to have to want to help yourself, and then they'll give you the tools you need, okay?
Yes, Your Honor.
All right. Good luck to you, Mr. Dash. I'm going to send you to breakout room number 1. Mr. McClain, you can go to 1, and Rebecca will probably be able to give you better information on the program.
Thanks, Judge. Appreciate you.
Thank
You're
you, Your
welcome.
Honor.
You're welcome. Have a good rest of your day.
You do the same.
All right. Eduardo Jimenez, who do you have? Eduardo Jimenez, who do you have? It's a Monday.
Yes, Judge, I have Brian Markle. Brian
Right.
Markle and CTD, I believe.
Okay, is there a reason? Well, we'll find out while we're here. Okay, I'm going to send you to breakout room number 8.
Okay, thank you, Judge.
Sure, no problem. All right, Lorraine Efron.
Yes, Judge. Okay, I think what we're here for is a bond reduction. And David Martin and I conferred, he cannot agree to a reduction. So
All right.
I guess we're requesting a.
Oh, yes. So you're also here for discovery compliance as well. So it's discovery compliance and bond reduction. All right, just give me one moment. Alberto Rodriguez?
Yes, Your Honor.
Yes.
Okay, here's what we come up with. He's apparently awaiting indictment on an aggravated kidnapping. So that's apparently a new case. And Mr. Garcia has put in a call to the intake to find out exactly what the circumstances are. He is going to let me know today or early tomorrow morning about this case. He has not made an offer yet because it's all on hold because of the kidnapping.
Okay, and I see where you are recently appointed on this case.
Yes, I was.
Yes. So Norma, can you give them a 30-day reset, please, on Jesse Solis?
Yes, ma'am. Give me 1 second. It'll be August 23rd, Judge.
All right, so we'll come back on August 23rd.
Okay.
And at that time, the state should be able to make you an offer.
Okay. I do have a situation, and I think the state wants to proceed as soon as they can because Judge Mayor Roman has advised me that she has 2 cases on hold for him, and he's way up because the cases are very old, and she's not going to wait.
Okay.
So
did you want a quicker date than August 23rd?
No, I'll just wait to hear from Mr. Garcia.
All right. I don't know why this is the first setting on this case, and it has an indictment number of 2020. We'll find out about that.
Well, I think I know, Your Honor. I've been licensed long enough to know.
Okay. Yeah, we know, but we'll put it on the record.
No.
All right.
Okay.
All right. Thank you, Mr. Rodriguez. Do you need to speak with your client anymore?
No, I'm going to talk to him in person after this.
All right. Thank you. Have a good rest of your day.
Thank you.
All right,
Bye-bye.
Norma, can you let them, bye-bye. Norma, can you let them know that L5 can go back?
Yes, ma'am.
All right, and Lorraine Efron, we're ready on yours? Lorraine Efron.
Yes, Judge, I'm sorry. I put it on mute. I'm so sorry.
No problem. All right, the court is calling 2021 CR 3890, State of Texas versus Joe Dela Cruz. Could I have parties announced for the record for the state?
David Martin.
For the defense?
Lorraine Efron.
And are you Mr. Dela Cruz?
Yes, ma'am.
We're proceeding by video. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Dela Cruz, do you have any objection to this hearing taking place by video?
No, ma'am, Your Honor.
All right. So we're here for 2 issues. One, discovery compliance. Defense, have you received all the discovery?
You know what, Your Honor, I remember there's a voluminous amount of discovery that I got served with right before the last setting. And I just honestly have not had a chance to go through it all. I think it's maybe hundreds of phone calls. And so I'm not prepared to say 100% that I have all the discovery today, but I will keep working on that, of course. I don't know how you want to handle that.
Okay. State, have you been prepared to tender an offer yet or no?
I mean, yeah, I can make an offer today if she wants one.
Okay. What we're going to do, Ms. Efron, with regards to discovery compliance, we're going to recall this in 3 weeks for discovery compliance.
Okay,
So at that time, I'm going to need to know whether or not all the discovery has been completed and you have it.
okay.
All right. Now,
Um,
yes.
Oh, I was going to ask if Mr. Martin could send me a discovery acknowledgement. That way I can go through his list and see.
Okay. Now
Yeah, I can send you the whatever is the index for you to go through.
Okay.
Okay, awesome. Now, the next issue we're here for is the defense is requesting a bond reduction. Defense, it's your motion.
Yes, Your Honor. Mr. De La Cruz has a bond set at $75,000 currently. He's asking for a reduction of to $35,000 or $40,000. He has ties to the community, family here. He's from San Antonio. He's indigent. I'm court appointed on the case, and he's not able to make a $75,000 bond. But he believes that his family and friends can help him make a lower bond, and he's willing to do a full house GPS arrest or whatever other bond conditions the court would deem necessary in this case. And so we're asking for a reduction and whatever bond conditions the court deems necessary.
All right, State.
Judge, we're opposed to any bond reduction at this time, and I've forwarded to the court reporter and the defense. I intend to offer State's Exhibit 1, which is the prosecution guide, and State's Exhibit 2, criminal history report for the defendant.
All right, any objections from the defense?
No, I'm pulling it up right now. No, for purposes of this hearing, no objection.
All right, State's Exhibits 1 and 2 is admitted for this hearing. All right, State.
And that's all we have.
All right, defense, it's your motion. Do you have any other witnesses or do you have any witnesses?
I just have my argument today, Your Honor.
All right, the court will hear argument.
Mr. De La Cruz is indigent. I'm court appointed on the case. He's been in custody since the day of arrest. He's been unable to secure a bond at the current amount of $75,000. And he is asking for a reduction of that bond. And again, asking for and willing to comply with whatever conditions the court deems appropriate. He has a longstanding connection to the community and has a low risk of, he's low risk in terms of making court appearances. He'll make his court appearances. And so we're asking for a reduction to $35,000.
All right, State.
Judge, based on the state's exhibits, we're opposed to a bond reduction for the safety of the victim and the community. I will point out that he is also indicted as a repeat offender. So his minimum term of imprisonment would be 15 years.
All right, and what is the sentence that makes him a repeat offender? The nature of the sentence?
It's an aggravated robbery.
All right, defense, it's your motion. I'll give you last argument.
Your Honor, he will make his court appearances, especially if the court puts bond conditions on there. I think he would be a benefit from being on bond with conditions, including mental health monitoring and participation in mental health programs. And so we're asking the court to please consider a reduction with those kinds of conditions.
All right, motion for bond reduction is denied. The court will also add GPS, full GPS. Court will waive the fees and place the defendant on indigent status. Norma Ferguson, could I have a 3-week reset, please, for a discovery on Joe Dela Cruz? And defense, if before
Honor,
that
can I-
time period, just one moment, Mr. Dela Cruz. Defense, if before that time period you have gone through the discovery, just let the court know and we'll drop the setting.
Okay, that's great. Thank you, Judge.
All right.
August 16th, Judge.
All right, we'll come back on August 16th. Mr. Dela Cruz, is there something you wish to say?
Yes, I would like to discuss something with my
I'm sorry, what did he say? What did you say, Mr. Dela Cruz? You went out.
may please have a moment with my attorney to speak to her about
Yes.
something that was
Yes,
on
I'll
this
send
case.
you to a breakout room with your attorney.
Thank you, Your Honor.
You're welcome. Ms. Efron, if you'll go back to room number 7. And Mr. Dela Cruz, I'll see you to 7. And Ms. Efron, when you finish speaking with him, you can bring him back to the main room so he can be excused.
Okay, thank you, Judge.
All right, anyone else back from the breakout rooms?
Good morning, Your Honor.
All right, just one moment, Mr. Guerra.
Yes, ma'am.
Mr. Contreras? We're going to have you brought over tomorrow to the courtroom. Do you understand? All right, Norma, if you can let them know 14L can go back. All right, Mr. Guerra, who are you here for?
Yes, ma'am. I'm here for Jonathan Yost. I believe I'm still waiting on Mr. Cox to arrive. And then once he does, we have the discovery hearing. And then I also have 3 matters that I'd like to discuss with the court, if that's all right.
All right, thank you.
Thank you, Your Honor.
Just give us a moment and we will get Mr. Cox here. All right, Valerie Hetland.
Yes, ma'am. We should be ready. We had some email difficulties there.
All right, let me see if I've received any of the paperwork. All right, I'm going to send you and your client to breakout room number 1. Sorry, there's someone in there. Let me see. Yes, if you and your client will go back to breakout room number 5, the clerk is in there and they'll go over paperwork.
Okay.
All right, Mr. Jenkins, if you go back to number 5. Let me move your client to 6 just in case he needs to see the pop-up.
Okay. There we go.
Thank you. All right, Normie, can you let them know that L4 can go back?
Yes, ma'am.
All right, and Cornelius Cox, I thought he came in. Hi, Mr. Cox.
Judge.
Yes, I know you love your Florida Gators or whatever team, but Hat needs to go.
I'm sorry, Judge. I didn't realize I.
That's okay. Sometimes sometimes we're all in our feelings with our team.
Yeah, no, just so intense this morning. I didn't realize that I would not want to show any disrespect to this honorable court, Judge.
Oh, thank you. All right, if you can go to breakout room number 9, the prosecutor will meet you there.
Thank you.
You're welcome. Eli Rico.
Yes, Your Honor. I just spoke to Hunter and he made an offer. My client is in agreement with the offer that was made. So I guess we need to reset it for a plea. We need to receive the documentation, obviously, and discovery.
Oh, no, we can do that today.
Oh, we don't, okay.
Yes.
Okay.
What you'll need to do, put in the chat box to Ms. Ferguson your client's email address.
Okay, okay.
All right. And Mr. Villarreal, I'm going to send you to a breakout room with your attorney. I'll send you to breakout room number 5.
Number 5, and what do we need to put in to Ms.
Ferguson and the state? They need your client's email address.
Perfect. Okay. All right. Thank you, Your Honor.
You're welcome.
Mr. Rico, I also need your email.
I'm sorry. You need my email?
Yes, sir.
Okay. Let me send it over to you.
Meredith, can you hear me at all?
Yes.
He said he would take the 180.
Your Honor, this looks like
Yes.
it was set. It was, I don't know why it was set, but it was pre-indictment. And so I just made a pre-indictment offer. But I'll get a waiver number if we want to get that done today.
Okay, yes, let's do that.
Okay. And Meredith, just to be clear, the rest, you're TICing the rest of the charges, right? Including the misdemeanor.
Correct.
Okay. All right. That's good. Okay.
All right, Meredith, Robertson, breakout room number 6. If you want to go there, he'll give you a waiver number.
Okay, thank you.
Judge, with your permission, I'll be back in just a little bit. I have to go to a hearing really quickly.
What does a little bit mean?
Well, I have a 10:15 in the 437th hearing. It shouldn't take too long, hopefully.
What does not too long mean?
Well, I don't know because it's Judge Skinner has to do docket call, and then we're supposed to have a hearing right after that on a motion to set bond. She said 10:15, so I don't know. Trying to juggle those two things. I can keep my computer on and start filling out the paperwork. As I'm
Yes, let's do that.
Yes. Okay. Okay. Thank you.
Thank you. All right, are parties ready on Kevin Jenkins?
Defense is ready, Your Honor.
Who is the prosecutor you're working with?
Marcus, and there he is. I know he's ready.
Okay. All right, the court is calling 2020 CR 0528, State of Texas versus Kevin Jenkins. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Valerie Headland.
We're proceeding by video. Any objections from the state?
No objection.
Any objections from the defense?
No objections.
Mr. Jenkins, I'm showing you a document entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review that discovery with your client?
Yes, we did.
Court will find that the state is in compliance with discovery. Mr. Jenkins, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney and did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, Mr. Jenkins, I just have a question for you before we proceed. Did you just wake up this morning and were rushing to make it on time to
Yes.
this Zoom?
Yes, ma'am.
Right. So you're not properly dressed, correct?
I wasn't. I like. Yes, Your Honor.
Like you're still not properly dressed. You know that, right?
I just threw a jacket on and I threw some pants on, like presentable to cover up my body and look presentable, at least like.
And those pants are not pants; those are shorts.
Well, this is all I got, Your Honor. I'm struggling right now at the moment.
So you're telling me in all your time, how old are you?
I'm 29 now.
So you're telling me in all your time on this planet, you've never owned a pair of pants that went to your ankle?
What do you mean like pants that like cover my
Yeah, you're telling me the only pair of pants that you own since you're 29 years on this planet, or since the time you've been an adult, are a pair of shorts. That's what you're telling me, because you're wearing a pair of shorts right now.
No, Your Honor. That's not. That's just all my clothes is dirty, and I didn't they're actually in my vehicle, and I was supposed to go do laundry last night, but I ended up didn't going to do the laundry because I got overwhelmed with things. I do side jobs and everything, so I just wanted to come home and get some rest for real. And I didn't know I had to be fully dressed because this is my first time doing this, and I apologize.
So you don't know that you have to dress appropriately for court. I made that announcement at the beginning. I said, whatever you could not do if you were physically in the courtroom, you can't do on the Zoom screen. So if you were to come to this court, you would not be allowed in because you're wearing shorts. Do you understand that?
Yes, Your Honor. I did not know that. I'm sorry.
Okay, what is up? This is the same thing with people wearing shorts to church, taking out of context the come as you are, which doesn't mean come as you are wearing shorts, wearing what you wore to the club last night. And so I don't know why people would think you can wear shorts to court. How is that respectful to the court?
It's not, Your Honor. I didn't know. I apologized.
And I'm sure as a defense attorney, I never thought that I would have to tell clients how to dress for court, because I'm like, well, Stephanie, that is very condescending of you to tell somebody how to dress for court. And then I had clients who come in, I said, okay, you know what? I got to tell them how to dress for court. So somebody said, oh, just tell them to dress like they're going to church. And then I realized I couldn't even tell clients to dress like they were coming to church, because people started wearing things they wore to the club last night. So I'm going to continue with this, but let me just tell you, the next time you are in this courtroom on this Zoom, you will be dressed appropriately. If not, you will not be allowed to appear by Zoom again. Do you understand?
Yes, ma'am.
I'm going to show you what's entitled Court Admonishments. Have you reviewed that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
You're charged with the offense of evading detention second or more, state jail felony. The range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility, and
Judge,
up to
I'm sorry.
10,000.
Is that the case that we're proceeding on? I thought it was the
They gave me a different file. Just 1 second. Thank you. All right, Brenda, we're back on the record. All right, the state is proceeding on cause number 2020 CR 0534. What you're charged with in that cause number is unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
All right, everyone, just one moment. That's the case they're going on. Oh, no problem. Yes. It's Monday. Thank you. All right, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, grant the motion, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Jenkins, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state recommends deferred adjudication. They will take in consideration 2020 CR 0528, restitution to NEAN Holdings LLC. Did you understand that to be the agreement?
Yes.
Defense, is that the agreement?
Yes.
State, is that the agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 150 hours community service restitution, and CATS 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
Yes, Judge. State offers State's Exhibit 1 and its attachments.
No objection, Your Honor.
Mr. Jenkins, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Jenkins, I apologize on his behalf. Also, I've been homesick for the past week, and I normally go through the Zoom attire and requirements. I'm not able to see that has shorts on, so my apologies, Your Honor. I should have done a better job in preparing him for today. Having said that, Mr. Jenkins wants to put this behind him and make amends and get on to bigger and better things. Your Honor, he's struggling to get his identification. He's working on getting his Social Security card. He's moved here from Des Moines, Iowa, and he has a wife and works odd jobs and is doing the best that he can. And Your Honor, we would ask for you to take that into consideration in granting his application for deferred.
All right, how far did you go in school, Mr. Jenkins?
I got my GED, Your Honor.
What are you planning on doing with the rest of your life?
I'm a mechanic. Like, I love to work on cars. I'm really multitask. Like, I have a lot of trades and stuff like that. Like, so like I went to school for welding and stuff like that. And like that's the stuff that I really like to do. I just haven't actually sat down and took my time to do it. Like, and I'm ready to change and do that. Because the life that I was living when I was back at home, that's the only reason I moved up here to Texas, to change my life. If you knew the situation, how I got this situation that I'm in right now, you would be like, wow. Like, because I'm not a trouble type of dude. Well, guy, sorry about that. I'm just ready to change, Your Honor. That's it. I'm tired of living the street life. That's it.
Do you have any children?
No, Your Honor.
All right, so where do you work?
Right now I do Dan's lawn care. It's like through PPS Temp Company on Parent Vital. I'm really not from here. I just know the address, like 3800 Parent Central, and it's like a daily temp. So every day I just get work and make little odd dollars and just save up.
So when are you planning on doing whatever you're going to do with this mechanic business that you want to go into, or welding? When is that happening?
It's as soon as possible, like soon as I can get it, like actually in position, because they want me to get like a little license or something, like for the state for the thing that I want to do. I want to get a pickup truck, put my logos on the truck and do all that. Like, they want me to have some type of license or something, like a business license, or I guess that's what they said. Like, in order to have people working for me and doing the things I want, I don't really want to work. I just really want to put like
sometimes you gotta start at the bottom. Sometimes you gotta start in the mail room. You can't go out delivering mail. You understand?
Yes.
So this whole thing with you're waiting for whatever you're waiting for, as my grandmother would say, wait broke the wagon. So you need to start putting things into action. Otherwise, I'm going to see you back here and you're going to be back here and you're going to be telling me that you're still trying to put things into action. So it's like, we need to stop trying to put things into action and put things in action. So if they gave you a list of what you need to do in order to become what you want to become, you need to write that list down and you need to start checking off boxes because you've done certain things. Because otherwise, you're going to be getting up late another morning in another court, and you're going to still have this story that you're waiting to do A, B, C, and D. You understand?
Yes, Your Honor.
So whatever you're going to do, now's the time to start. And you say how old are you?
29.
You're going to look up, another 10 years going to pass. People think time is slow. Time moves very quickly. I mean, we've been going through this pandemic for close to what, 2.5 years now?
Yeah, it's crazy.
So there you go. So time moves quickly. Time waits for no one. So if you don't start getting your life together, you're going to wake up, you're going to be 60 and you're still going to be talking about, I'm going to be a welder. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication, take in consideration 2020 CR 0528, restitution to Ian Holdings LLC, 200 hours of community service restitution. That'll be waived if you obtain your welder certificate. Or in some type of trade school or higher education. And I will tell you, if you are saying that you're going to college in this court, that means full-time for this court. And so for this court, full-time is at least 9 hours a semester. I used to do 21 hours a semester, but hey, that was just me.
That's a lot.
Now when you really think about it, because the way I figured it out, Brenda, when I was going to college, in high school, I said, we had 6 classes a day. I'm in college. You only have to do Monday, Tuesday, Monday, Wednesday, and Friday, and Tuesday and Thursday. I'm like, this is a lot of time. It's just one class. And then I soon realized that the hours you take at a certain point, those over 12 hours, it may have changed, but over 12 hours, those are free hours. And of course, I didn't have a lot of money. So I said, you know what I'm going to do? I'm going to take 21 hours a semester. I got as high as 24 a semester so I could hurry up and get out. And then over the summer, I would do 12. And I only did 12 over the summer because that's the only thing they would give you. But it made for me to move out quickly and owe them less money than if I would have just been lazy doing, 9 hours. I was in college and undergrad with some people who had been in college for 6 years, still waiting to get their degree. Time passes.
Yes, time does pass fast.
Yep. We're going to do CATs 1 and 2. And if you're drug tested today, what are the results going to be?
Your Honor, I'm going to be dirty.
And what are you going to be dirty for?
Marijuana.
All right. And that's all?
That's it.
All right. Here's the thing. While you're on probation in this court, in any court in Texas, you're not allowed to use marijuana. We're going to test you, and we're going to test you for levels, and those levels need to start going down. So you're not allowed to use marijuana. And we'll do regular Zoom reporting. If you can't report by Zoom, you're going to have to do it in person. And when you report to them in Zoom, you need to be dressed appropriately. So that top is fine for Zoom, but just add some pants, long pants.
Okay.
We'll do random field visits 1 time per month. Rebecca, is there anything else he needs?
No, ma'am.
Anything else you need from me, Mr. Jenkins, in order to be successful on this deferred adjudication?
Oh,
No,
I'm
you're
sorry.
not.
Judge, the proof of employment.
Thank you. We're going to do proof of employment within 30 days. There's to be no employment as a home health care provider or supervision of minors. All right, anything else you need from the court, Mr. Jenkins?
No, Your Honor, thank you.
You're welcome. I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, Mr. Jenkins, here's the thing. From here on out, and Brenda, we can go off the record. From here on out, everything you do, you need to ask yourself, is this something that could potentially place me in the state jail facility for 2 years? With the marijuana, sometimes people are like, I don't want to give up marijuana. So you may need to ask yourself, is marijuana use worth 2 years in the state jail facility? You understand? And that's day for day time. So I'm going to sing. Yes.
Okay. Like, okay. So like the thing now, like get about Texas, like.
Evan.
All right.
Oh yeah, he wants to get into the rules. Hey, that's what voting is for. And
No,
that's why
that's right.
Call your legislature. I'm just here to follow the law. So I'm sending you to breakout room number 1. And probation will meet you in number 1.
Your Honor, may I ask something really quick? Since I've been appointed on this, he's had warrants, and I couldn't find what those were for, apparently. So Marcus and I worked out this agreement. So is there anything that we need to do as far as the warrants that he had on these 2 cases?
Oh, if you go to breakout room number 1,
okay.
Probation will let you know. The clerks will let you know if there's anything else in the system.
Okay. All right. Thank you.
Thank you. Could one of the clerks go to breakout room number 1, please?
And Kevin, you too.
So, excuse me, Judge. So we were doing the drug test today?
Yes. Okay. Get levels.
Okay, thank you.
All right, Cornelius Cox. And then we'll take up John Gilmore. All right, Cornelius is standing off to the side. John Gilmore?
Yes, Your Honor, my computer crashed. Kurt May's still in a breakout room. I don't think we've had the opportunity to meet with the prosecutor yet.
All right, and you're in number 3. What is your client's name?
Rogelio Espinosa.
And is it criminal trial division or family violence?
Family violence, Your Honor.
All right, I'll send you to breakout room number 3.
Great, thank you.
You're welcome. Lorraine Efron, you're back.
And I don't have anything further at this time.
Okay, all right. You're excused then. Thank you.
Okay, thank you, Judge.
Yes. And to the clerks, could you go to breakout room number 1, please? And Normie, can you let them know that 14J Dela Cruz can go back?
Yes, ma'am.
Thank you. Richard Guerra, what is happening with you and Mr. Cox?
Your Honor, I provided Mr. Cox with all of the discovery, but one item that I'm still waiting to obtain. I'm waiting to obtain a document from the Office of the Inspector General of the Social Security Administration concerning Mr. Yost's Social Security number. I'm anticipating it'll be a self-authenticating document. I've reached out to the Secret Service to obtain it, and they're having a difficult time obtaining it, that specific document. The other issues that I'm encountering in this case, as I've discussed with Mr. Cox, is this case is like an onion. You just keep peeling it and peeling it and peeling it and finding more and more. And so,
well, sometimes you got to chop an onion in half, then you can see all the layers.
well, I tell you what. Oh, good, Mr. Cox is here. So as I've been preparing this case, the case in chief is fairly simple. However, my witnesses live in Louisiana, Los Angeles, and Round Rock. And so because Mr. Yost lives in Hawaii, want to make sure whatever date we get set for trial is a date we know we're going, so that we don't.
Well, first, where is Mr. Yost? That's the first question.
Judge.
Yes.
Okay, my problem is that he called me and I've had my secretary look up the case setting, and the only thing we showed was August 5th. And
all right, well, it's supposed to be here for this discovery, so.
Yeah, okay. And what I told him was that, hey, I told him August 5th. And as for me, if you give me tomorrow, I'll get him in. I told him August 5th.
You know what, Mr. Cox, it is very rare that people will fall on a sword these days. So I admire that.
Yeah, but I mean, when I asked Angel, I said, what's the date? She looked it up in the clerk and it has August 5th.
Okay, Cornelius, I know Angel, don't throw Angel underneath the bus.
No, so I told him August 5th. I told him August 5th, Judge.
See how he moves over there, Brenna. I said, don't throw Angel under the bus.
Well, yeah, I told him August 5th, and she looked it up, and that's the only day we had. So I apologize, Judge, but
no, I understand. It happens. So, State, you said there was some discovery. When are you going to have that extra discovery? That's the question.
I'm unsure. Hopefully within a week or two. That's my best guess. And then the other issue I'm having is I'm continuing. I think from what I gather, and this is unusual, but from what I gather, there's a community of people online that have been defrauded by Mr. Yost. And I think word has gotten out that he's got a case in Bexar County, because I've been getting calls from victims all over the country concerning Mr. Yost. This would be with respect to a punishment case. And for example, I know he was in Florida around June 25th. I know he was in Atlanta, Georgia, near the 1st of January, or at least in the first month of January. But as I'm continuing to get new information from new victims and from old victims, I'm continuing to have to obtain new documentation. And I'm going to provide Mr. Cox with a witness list to help clarify the discovery that's in there, and a 404 list. I think that'll help clarify things. But I know at some point we just have to set a cutoff date. But for example,
I'm going to give you guys a cutoff date.
Okay. For example,
go ahead.
Oh, for example, there's a complaint out of Los Angeles from the Screen Actors Guild office. I've gotten calls from people in Clearwater, Florida.
So what are you saying? You're going to subpoena Tom Cruise? Is Tom Cruise going to be here? You're talking about Clearwater, Florida, and Los Angeles Screen Actors Guilds?
Well, the majority of the complainants in this case are actually sort of lower. I think people that are just getting started. Though I do have a scheduling issue with one complainant, Sherry Johnson. She formerly lived in Los Angeles. Now she lives in Round Rock. And I do know that if we're not able to get to trial by September 1st of this year, Sherry will be unable to testify until January 1st of next year.
Oh yeah, that won't be happening. Here's the thing. People are going to need to subpoena whomever they need to subpoena, because this is not going through to January.
Okay, that's fine. I just wanted to make the court aware.
Yeah.
We can subpoena Sherry. It's just a matter of lost income. And I told her I would at least bring it up to the court.
Sure.
So that's just kind of the issue that I'm discovering is as I just keep getting new and more information. For a period of a couple of weeks, I was getting calls every day. And it's finally started to slow down a little bit.
Okay. All right, Norma, on Mr. Yost.
Yes, ma'am.
Can you reset this for the week of August 9th?
Yes, ma'am. I can do August 11th.
All right. So, Mr. Cox, you can disregard the August 5th date.
Yes, ma'am.
And we're going to be here on August 11th. That's discovery deadline date.
Okay.
And then, Mr. Cox, your client will need to be present on Zoom.
Yes, ma'am.
And State, have you tendered an offer to Mr. Cox?
Yes, Your Honor. I believe I offered 3 alternate offers, depending on the amount of restitution.
All right. So, Mr. Cox,
Yes,
when you
ma'am.
come back on August 11th, I'm going to give your client a plea deadline date. And after that, it's going to be a trial date.
Yes, ma'am.
All right. If there is nothing else, Mr. Cox, you're excused. Thanks for coming in from DC.
I appreciate it, Judge. It's tough out here. It's tough in DC. You know. All right. Thank you, Judge.
All right. You're welcome. Bye-bye.
All right. Bye-bye.
Thank you, Your Honor. May I please be excused?
Yes. Just a moment, please.
Do you have a SID number? A SID number or a date of birth or something?
All right, Eli Rico.
Yes, Your Honor, I just, we finished signing the discovery that was provided in this as well as the documents. However, the DA is asking that a good faith payment of $5,000 be made today. My client is willing to do that today. They've asked that the plea be entered this afternoon. However, I have a conflict because I have a mediation this afternoon. Could we do this in the morning? Recall the case in the morning?
What time is your mediation?
It's going to be at 1:30 today, Your Honor.
All right, and of course, mediations, they tend to take on a life of their own.
Correct, Your Honor.
All right, State, are you okay with recalling Mr. Villarreal for tomorrow?
Yes, Judge, I'm about to submit the upfront form to the check section.
All right, so we'll bring him back tomorrow at 9 a.m.
Thank you, Your Honor. I'll be on at 9 a.m. with him. Thank you so much.
All right,
Your Honor?
Yes.
Thank you, Your Honor.
All right, everyone, just give me a Ms. Phillips, we're going to bring you back tomorrow at the request of your attorney, and we'll take up the bond issues at that time. Norma, can you let them know that L25 can go back?
Yes, ma'am.
Kevin Stryker?
Just head out to the hallway. Don't get you in just 2 seconds.
No problem. You have Mr. Revis. What is
Good morning,
happening
Judge.
with Mr. Revis?
Judge, Mr. Revis is unfortunately in custody in the Valley. He got picked up apparently over the weekend. He is currently in Brooks County Jail. I don't know much about the case, obviously, but this is a recent development. But I don't know if it's a felony or misdemeanor charge. I believe it might be some sort of, allegation of having someone with maybe a human smuggling charge. But again, this is within the last couple of days that I got this information. So, but he is apparently in Brooks County Jail on a new charge.
So what are we going to do with this MTR?
Judge, I don't know what's happening now with Brooks County. In Harris County, there was some developments. The attorney was on vacation last week, but I think we're close to possibly resolving the Harris County case.
Yes.
This is now we're in Brooks County. Obviously, there's, so I just don't want to start speaking without knowing all the information, Judge.
No, I understand what you're saying. I know that we've been trying to get him help because this has been going on since April because he had the Harris County cases and then he didn't show up for his competency. So, and now he is in Brooks County Jail.
Yes, Judge. So again, I don't know if that's a felony. There was also a case out of Missouri, but that was a misdemeanor. And so we had talked to the probation department and the drug court, and they said they were okay with misdemeanors, but I don't know anything about the Brooks County case quite yet.
Okay. All right. Can I see you and a prosecutor in the breakout room?
Yes, Judge.
Marcus, are you available, or Meredith or Hunter?
Yes, Judge.
All right. I'm going to send you to breakout room number 2, Mr. Stryker.
Yes, Judge.
And Rebecca, if you could come with us to number 2, please.
Yes, ma'am.
All right, anyone back? All right, Norma, we need Christine McDonald.
Yes, ma'am, I'm trying to get a hold of her.
All right, thank you. Brenna, I'm trying to drink a lot of water because I took my allergy medication and otherwise you'll be super dry.
Judge, she's logging in.
All right, thank you. All right, Ms. McDonald, I'm going to send you to breakout room number 4.
Thank you, Judge.
You're welcome. And she will need a family violence prosecutor on Trisha Hudgens.
I'll meet her in there, Judge.
All right, thank you.
Rebecca, I sent you a message.
Ms. McDonald, do you still need to speak to your client?
Yes, if I can be put in a breakout room with Trisha Hudgens.
All right. Ms. Hudgens, I'm going to send you to breakout room number 4.
Sure.
Thank you, Judge.
Mr. Stryker, are you back?
Yes, Judge.
Yes.
Yes, Judge. Talked to Marcus. He ran the criminal history and was comfortable with what we talked about, Your Honor.
All right, thank you. Then you are excused. Thank you so much for your
Thank you,
help.
Judge.
The Norwegian
Excuse me, has anyone from family violence gone to breakout room number 3 on Rogelio Espinoza?
I haven't, Judge. I was talking to David about it.
Okay, all right. Oh,
I didn't even know
problem.
they were in there.
Yes, John Gilmore and Kurt May are in there.
Okay.
All right, thank you. Yes.
Judge, may I speak to the state one more time on Trisha Hudgens, please?
Yes.
Thank you.
If you'll go back to breakout room number 4, the prosecutor will meet you there. And what is happening on Rogelio Espinoza?
Your Honor, this is Kurt May. We just got out of our breakout room with the prosecutor. I've relayed to him the evidentiary issues that we are currently having. The first one we hopefully will remedy soon. We filed a motion for access to the cell phone that's in play as evidence. We need an independent forensic evaluation of that cell phone and the contents. The second evidentiary part of this case is Mr. Espinoza himself. He is nearly 70 years old. He's on medications for diabetes that have had some downside cross pharmacological reactions. We have been struggling with the family to get to his primary so that he can get a referral to a specialist, because it is a part of this case. It's part of the period of time where the allegations come from.
All right, what are you guys asking from the court?
Because we've had a backlog in getting that examination done and the forensics analysis, we're asking for a 45-day reset. We think that's a robust aspirational date, but I think it's reasonable under the facts.
Okay, because we were here on April 8th, and it says defense attorney and expert to watch video.
And we did that, Your Honor.
All right, and then we come back on May 13th. Defendant wants a trial. And then we come back on June 17th. Recall for today to file motions. So what motions have you filed?
We filed a motion for independent analysis of the cell phone that's in state custody.
All right, clerks, the defense said that they filed motions on Rogelio Espinoza. Could I have those motions, please?
Yeah, Judge, that was filed at 5:16 on Friday, so I'm not ready to do anything on that today. I've reached out to the detective to get some information from him, but I haven't heard back from him I need yet.
Okay, and the motions that were filed as the motion for an expert, correct?
It's yes, for an independent evaluation. It may follow that we need our own expert, but at first we need the analysis of the cell phone.
All right. And State, do you have any idea when that will be done?
Well, they want to get their own analysis done.
What defense is telling me is, I guess, the state has done an analysis. And so both parties can realize and everyone can realize, I don't know anything about the facts of this case. The only thing I know is your client is charged with continuous sexual abuse of a child. So I don't know anything other than that. So defense, you're saying that the state has already done an analysis. Is that what you're saying or no?
No, we're not. We don't know if they have done an analysis. We'd like to see it. But one of the allegations here from the victim is that pornographic material was shown to her on a cell phone. So it's an objective fact. Either it is on the cell phone or it's not. The other material fact here is at all places in time, that cell phone has the capability of showing where the cell phone traveled. So the alleged acts occurred at specific points in time. We want analysis of that. So if the state has that, we'd love to see it. We think we're entitled to it. But if they haven't done it, we want the opportunity to have our own expert do an independent analysis.
All right. So state, when will you have a chance to look to see if any type of analysis has been done on your offices in reviewing the cell phone?
I emailed the detective this morning when I got notice of their motion, and I haven't heard from him as far as the status of that.
All right, Norma, on Rogelio Espinoza, if you can recall this in a month, and everyone at that time, everyone needs to have whatever motion filed, need to have it filed, and make sure that the state has proper notice.
I can recall it back on the 30th, Judge, of August.
All right, we're going to come back on August 30th. Are there any other motions, defense, besides this expert?
Not at this time, Your Honor.
And who's paying for this expert?
Our expert would be the one that would pay for that analysis. However, your point is well taken. If the state's already committed to an analysis by an expert, we want that. That would be helpful.
All right, so we're going to come back on August 30th. And defense, if there are some other motions that need to be filed or that you're going to be filed, I'm going to ask that they be filed by August 6th.
Oh, thank you, Your Honor.
And state August 30th, will that give you enough time to know if an analysis has been done?
I would hope so. I would hope time in the next day or two. I'm not sure what schedule the detective has as far as what his days off are, but hopefully this week I would know something.
Okay, is there anything else from either side?
Not from the defense, Your Honor.
All right, thank you. You and your client, Mr. Espinoza, are excused.
Thank you.
You're welcome.
Thank you, Your Honor. Have a good day.
All right, thank you, you too. Happy Monday.
Judge, can I make an announcement on Trisha Hudgens?
Yes.
Judge, we have not come to an agreement on the bond motion. If we can proceed in front of the court.
Yes. Who are the parties on this?
It's just my
Correct.
client.
All right.
Christine, can you send me your email in the chat, please? I don't have your email.
Yes.
Thanks.
Mr. Garcia, was that you who said that? Sorry.
Yes, that's me. Yes, I asked for it.
All right. Court is calling NYMAC number 621069, State of Texas versus Trisha Hudson. What did I just say? Hudson. I'm putting letters in there. Hudgens. Can I have parties announced for the record for the state?
Joey Garcia.
For the defense?
Christine McDonald for the defendant.
All right. Are you Miss Hudgens?
Yes, Your Honor.
We're proceeding by video with this hearing. Any objection from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Ms. Hudgens, do you have any objections with this proceeding by video?
No, Your Honor.
All right, defense has filed a motion requesting a bond reduction. State, have you had a chance to review the defense's motion?
Yes, Judge, we spoke about it.
All right, are you ready to proceed, state?
Yes, Your Honor.
All right, defense is your motion. You may proceed.
Thank you, Judge. May I take testimony from my client?
Yes. Ms. Hutchins, you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand. If you could state your name for the record and spell it, please.
Trisha Hudgens, Trisha. Hudgens, Hudgins.
All right, defense.
Thank you, Judge. Ms. Hudgens, without going into the facts of the case, what day were you arrested?
June 3rd, or July 3rd, sorry.
Since that time, have you been able to post the bond at what it's currently set?
No, ma'am.
Do you have any family members here in San Antonio?
No.
Tell me a little bit about your family.
I've got a grandmother that's somewhere between Virginia and California. I do not have any contact with her. I've got a father who's in prison somewhere who I do not speak to. I have no mother. She passed away a long time ago. My fiance is currently here in prison. I don't have any family members that I know of around.
Okay. Where were you living? Where was your last address that you were consistently living?
436 Nassau Drive, NASSAU. It's a friend of mine. She was helping me as far as getting through services with SAM Ministries to get into my own place.
Okay, this friend that which you were living with, does she work at, I'm sorry, what was that ministry?
No, she doesn't work at SAM Ministries, but she works with them.
Okay.
She works as a personal care assistant. But yeah, she was trying to help me get services, and she was making sure that I wasn't on the streets while I was getting help.
What's her name?
It's Jeree Bales.
Do you think that if you were able to bond out that you'd still be able to live with her?
Yes, ma'am.
Would you continue working with her in SAM Ministries to get on your own 2 feet and get your own housing?
Yes, ma'am. I want to change my life and get on my feet.
Were you employed before you were incarcerated?
No, I was pregnant, so I couldn't be employed, but I was employed before I was pregnant. And I was waitressing. I'm willing to go back to waitressing or do whatever, job that I have to do. It could be simple as cleaning floors and housekeeping or whatever. I need a job and I want to get that taken care of. I'm no longer pregnant, so.
Okay, so you've had the opportunity to discuss several treatment programs available on bond with me. Did we discuss the ITP program through Haven for Hope?
Yes, ma'am.
Have you been previously diagnosed with any type of mental health illness?
Autism, ADHD, ADD, bipolar, chronic depression, and currently postpartum depression.
When was the last time you received treatment for your diagnosis?
I was a child when I was diagnosed with my bipolar. They put me on a set of medications that didn't agree with me, and being as a child, I couldn't really, get that switched around, but I've been wanting to get help with mine lately.
Would you be willing to get help if the judge were to allow you on bond with the condition that you stay in the ITP program through Haven for Hope?
Yes, ma'am.
And do you understand that that program, you would not be able to leave the facility for anywhere up to 90 days?
Yes, ma'am.
And you understand that you'd also have to work your way up to privileges, including the right to use a cell phone?
I understand that.
Okay, and knowing that, is that something that you'd be willing to do?
Yes, ma'am.
Okay. Other than this charge here, have you ever been arrested before?
No, ma'am. I don't have any criminal history whatsoever. This is my very first charge.
Okay, is there anything else that you'd like the court to consider when the judge is deciding whether or not to reduce your bond?
Just that I currently have no family or no way to really bond out right now. I'm willing to change my life and work towards things. I'm putting my daughter up for adoption. So I've got time to work on things for myself to get on my feet better. And so I'm not back here in this court.
Thank you. I have no other questions, Your Honor.
All right, State.
Judge, the state is offering State's Exhibit 1 into evidence. We're emailing.
All right, and do you have any questions for the witness or no?
Yes, we do. But I'm just emailing the State's Exhibit 1 right now to defense, court reporter, and yourself. Okay, that has been sent. Ms. Hudgens, when was Hope Serenity Collins born?
10:30 a.m. on July 2nd.
On July 2nd, 2021?
Yes, ma'am. Yes, sir.
And is that the same day you were arrested?
Well, I didn't, my arrest date is the 3rd right now because they had to take me to the hospital and everything.
Okay, so technically you're arrested just the next day after giving birth to Hope Collins?
Yes, sir.
And you're arrested for endangering a child?
Judge, I want to object. This is getting kind of close to the facts, and I would just like to make it known that my client has not been convicted of this, Judge.
All right, I'll overrule the objection as far as to the question of whether or not she was arrested for endangering a child. I'll overrule that objection.
Yes, sir. Yes, sir. That's what I was arrested for.
Okay. And Judge, I won't go into the facts, but I did enter State's Exhibit 1, which was the day after the child was born for endangering a child. And
all right, any objections to State's Exhibit number 1 being offered into evidence?
No objection, Your Honor.
All right, State's Exhibit number 1 is admitted for purposes of this hearing. Any other questions, State?
No questions, Judge, just argument.
All right, defense, any questions?
No questions, just brief argument, Judge.
All right, defense, it's your motion. I'll hear your argument.
Thank you, Judge. Your Honor, my client has absolutely no one to help her with this bond. Any amount she's not going to be able to post it. I would ask this court to consider a PR bond with the condition that my client be required to attend the ITP program through Haven for Hope. If this court allows that, I would get with my case manager to coordinate getting her a bed in that system, Judge. My client would agree to any other conditions, including GPS monitoring, but I would just respectfully request that if GPS monitoring is going to be a condition, that the fees would be waived because she is indigent. Your Honor, my client's never been arrested before. She has several mental health diagnoses that I think she could benefit from treatment from, Judge. She's trying to do the right thing, and we're just asking you to allow her that opportunity. And I'm sorry, and to either grant a PR bond, Judge, or to reduce it in the most amount that you would feel comfortable.
All right, State.
Yes, Judge. I believe that this is still under Title V of the Penal Code for Family Violence. I'm not sure if it's endangering child. I'm not sure if the governance ordinance is still in place for PR bonds. If it is, that would be a reason for a PR bond not to be granted. The state is opposed to the reduction. We believe it's a reasonable amount given the nature of the offense and for the defendant to appear in court. Judge, and given State's Exhibit 1, it was one day after a child was born, placed into a backpack with a blanket, with the backpack zipped up. That is the nature of it, and we believe that the amount is reasonable at the moment. So we ask that the motion be denied.
Does the defendant have any criminal history?
No, Judge, not that I see in Bexar County.
Has there been a search done outside of Bexar County?
I don't have that information right now, but I can request it.
All right, is there anything else from either side?
None from the state.
None from defense, Your Honor.
All right, this is what I'm going to do. Because the court would like to know if the defendant has any criminal history outside the state of Texas before I make my ruling, because as everyone knows, I like to have all the information to make a just ruling in any case, but certainly in bond issues as well. So State and Ms. McDonald, do you all think you'll have that by tomorrow for me?
I will, Judge.
I don't have access, Judge, but if the state can get it, I can be back here tomorrow.
Okay, so Ms. Hutchins, what we're going to do is we're going to recall your case tomorrow, and we'll be here tomorrow at 9, so I can have that information on your criminal history. I know that you're telling the court that you have no criminal history, but sometimes people tend to forget. I'm not saying that you've forgotten in your case, but I just want to have some documentation on whether there is any out of county or out of state criminal history. All right, Norma, on Tricia Hutchins, can you recall that for tomorrow? And it's just for the court to obtain information on any criminal history and to make a ruling.
Yes, ma'am.
All right, do you need to speak with your client anymore, Ms. McDonald?
Just briefly, Judge, and then may I be excused after that?
Yes, but if you'll have her come back to the main room, because we'll need to excuse her from this room.
Sure, yes, Judge, thank you so much.
You're welcome. I'll send you out a breakout room number 2. All right, Norma, can you find out where Eduardo Jimenez, I know he said he was going to another courtroom, but that appears to be taking longer than anticipated.
Yes, ma'am.
And yes, Rebecca.
Can I see in a breakout room, please?
Yes, number 1. Brenda, whenever people get called to the breakout room, doesn't it feel like you're going to the principal's office? You know, it's like in high school, I got called to the breakout room. I mean, to the principal's office. And then they're like, oh, we're just here to give you an award. I'm like, oh my gosh, I was trying to figure out what did I do wrong? So let me go to the principal's office.
Did I hear correctly that her family is somewhere between Virginia and California? So somewhere in America? Okay, just I'm sure I heard that.
All right, Norma, you can let them know that L27 can go back.
Yes, ma'am.
And Mr. Markle, we'll just wait. We're just waiting on your attorney.
Yes, ma'am.
Judge, I do show that Mr. Jimenez has signed the paperwork. He's just not here yet.
Okay, all right, thank you. And for some reason, I have case files on a Kevin Miller and Victor Vela. So we'll see. I don't see that on the docket. Kevin Miller is 2021 CR 4766. And Mr. Jimenez, I'm going to send you to breakout room number 2.
Great, thank you, Judge.
And Mr. Markle, I'm going to send you to 2. And everyone, just give me a moment. All right, are we back? All right, Mr. Marco, I'm going to send you to a breakout room so the clerks can swear you in. I'm going to send you to breakout room number 1, and if a clerk could go to breakout room number 1 and swear Mr. Marco in, please. You're welcome. Oh, thank you. Oh, you can take this one back. All right, are we ready on Mr. Markle?
Ready, Your Honor. From the defense side, I don't know about the paperwork. I don't know about the rest.
Oh, yes, we have the paperwork.
Okay.
Yes, Judge.
All right, the court is calling 2021 CR 6681W, State of Texas versus Brian Wayne Markle. We're going to have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense.
Eduardo Jimenez for the defense.
And are you Mr. Markle? If you could unmute for me, please.
Yes, ma'am.
We're proceeding by video. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Judge.
Mr. Markle, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Markle, I'm going to show you a document entitled Waiver of Indictment, Freedom of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. If you review that document with your attorney, did you understand it, and did you electronically sign it?
Yes, Your Honor.
Did you understand that you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict this case and hold you over for trial?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
Did you understand that your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up all of these rights that I've explained to you and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, freedom of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm going to show you a document entitled Information. To review that document with your attorney, did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
We do, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Markle, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Do you understand what you're charged with is possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and a right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
I'm sorry, Your Honor. Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he's competent, Your Honor.
Mr. Markle, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you into this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Definitely, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived its right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney, and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 180 days in the state jail facility. There's a $1,000 fine. There are no applications for community supervision or deferred adjudication. State will take in consideration the following cause numbers: NIMAG number 609801, 609802, and County Court cause number 662150. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Judge.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Judge.
Then Mr. Marco, to the offense is charging the information. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
State offers State's Exhibit 1 and all attachments.
No objections.
Mr. Marco, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, laboratory reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
The court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed those documents. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Judge.
All right, the court will follow your plea bargain agreement, sentence you to 180 days in the state jail facility. There's a $1,000 fine. Time and money will run concurrent. Give you credit for any time served. Take in consideration NIMAG number 609801, 609802, County Court cause number 662150. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Mr. Marco, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, with that, we will close the record. Mr. Markle, was it painful to get that piercing?
No, ma'am. It was painful, but like not as bad as you would think. It's just like a little slice, and then they push it in and pop the top on it. It kind of hurt a little bit.
Okay, well, Mr. Markle, I've read the report. If you have a drug or alcohol problem, there's plenty of help you can get that's free throughout the city. If you don't get help for your alcohol or drug problem, this is what's going to end up happening. You're going to end up either one or two things. Either you're going to end up going in and out of prison for the rest of your life, or either there's going to be a bad chemist out there who doesn't know what he's doing. You're going to get a bad batch and you may end up dying. So what you choose to do with the rest of your life is completely up to you. That 180 days, maybe it'll give you a chance to rethink things and find out how to do things differently. You understand?
Yes, ma'am.
All right, Mr. Marco, good luck to you.
Thank you so much.
All right, you're welcome. All right, Norma, can you let them know that L7 can go back, and Mr. Jimenez, you're excused.
Thank you.
All right, and with that, everyone, we are done for today. That's shocking. Usually we're back here at 5 p.m. But everyone, it's been a great Monday, right? So I'll see everyone on